So our panel today is going to talk about encryption. I think anybody who's opened a newspaper or turned on the news in the last 6 months can't have failed to pick up on the fact that encryption is huge news these days. Certainly, probably everyone in this room is aware of the major case involving Apple and the FBI. For those of you that haven't been so entrenched, around 2 years ago, Apple and then later Android moved to operating systems that were encrypted, what we might call full disk encryption. And hopefully my panelists will correct me if I'm getting any of this wrong, that prevented anybody, including the phone's manufacturers, including Apple and Android, from actually accessing the phone. Ostensibly, only the phone's owner or the person who had the phone's passcode, which was actually tied to the decryption key, could get in. This became an issue in the San Bernardino shootings when the FBI wanted access to the iPhone of one of the shooters who was deceased. They brought Apple to court. Apple refused to help them. For all the reasons I just said, Apple itself actually couldn't access the phone either because they don't have the decryption key. But there are ostensibly some things they could do, like change the way that the iPhone locks people out after a certain amount of time, or lets people run serial passwords, running different sorts of password combinations to see if they could get in. Apple brought the FBI, or FBI brought Apple to court, and the case was ultimately actually withdrawn after the FBI paid a hacker $1.3 million to access the phone. And so we haven't gotten a legal resolution on that question yet, but it raises really important issues on both sides for all of us. So the case may be over, but the issues are absolutely not going to go away. And so, Alex, I guess I'm going to start with you. So the District Attorney's Office of New York has taken a fairly strong stand against this kind of encryption, and some of the arguments that they have made have been to say that what they're not looking for is what we might have seen. So there were arguments in the past that really the government should just have a set of keys in escrow and they should always be able to access phones. You might have heard it described as a clipper chip. What they're saying today is that that's not what they're looking for. What they're looking for today is just for Apple and these other companies to return to what they did before and actually just themselves retain the key. And by doing that, simply make themselves amenable to search warrants, because where we are today is that even a lawfully executed search warrant can't get Apple to decrypt these phones because they actually can't. So what's wrong with that?
So first of all, let me say I'm delighted to be here and excited to have this conversation with you, Ben, and Dana moderating. I'd like to broaden the debate just a little bit, because I think Apple, the Apple FBI case is obviously the impetus for much of the national focus on this issue, but the question is a much broader one that actually dates back to the 90s when there was a first controversy in this country over the availability of encryption, widespread availability. That's when the clipper chip was first proposed as a solution. And today we're now relitigating this question again, so to speak. And fundamentally, what law enforcement agencies, including this district attorney in New York, have been asking for the last year and a half, 2 years, also joined by FBI Director Comey, is a backdoor into the encryption that many of us rely on to secure our communications and our sensitive data. And the fundamental problem with a backdoor is that it is disastrous for cybersecurity. We now live in what I think can be fairly characterized as the Wild West of the internet. You cannot open the newspaper, nearly any week and not see stories about a major hack of information, a company that's data has been hacked, whose customers' information have been exposed. It has supplanted, this threat of cybersecurity has supplanted terrorism as the #1 threat to this country, according to just about any national security official that you ask, including the Director of National Intelligence, James Clapper, who has said that cybersecurity is now, the threat of cyber attack is the #1 threat to this country. And the cornerstone of our defense against that sort of attack is strong encryption. Encryption that is unbreakable, at least if it's implemented properly. And it's for that reason, perhaps no surprise that just about every national security official that has left government has, since leaving government, said that they support Apple in this fight. They support Apple because they think that we as a country are safer in the end when our networks and our data are secure against invasion by malicious hackers, by foreign governments who are becoming increasingly sophisticated and increasingly seeking to attack our digital infrastructure. That is kind of on one side of this debate. Now, there are there are kind of two sides to the balance. The one is, what is the harm of having a backdoor? And I think that's the harm, is that encryption is the key to our digital security. And on the other side of the debate, you have claims being made by the FBI director, by the New York District Attorney, that the internet is going dark. I quibble with that characterization of the current state of affairs, because I think a much more accurate one is to say, as some commentators have, that we actually live in a golden age of surveillance. Never before has the government had as much access to as much information as readily as it does today on all of us, if it wants it with appropriate legal process. Most of you are probably carrying a very sophisticated tracking device in your pockets right now that reveals a lot of information about where you are, who you're communicating with, where you're sleeping, who you might be sleeping in proximity to. All of this information, it did not exist before. It did not exist before, for most people, 2006, which I think is when the iPhone first came out. But even charitably going back to the 90s when people first started getting online in force and these digital trails started being generated. So I think you have to kind of balance the cost of the backdoor against the reality that law enforcement has access to so much information. And I think the kind of proof of that is if you were to ask any law enforcement official, and maybe Ben, I'll ask you this question, would you prefer to have the investigative tools of today, but with encryption, or the investigative tools of the 1970s prior to the kind of development of the modern cryptography? And I think most people would choose today. But maybe I'm wrong.
Well, notwithstanding appearances, that was before my time. So, so I'll beg out on that. It's hard to say one or the other. What we do have, though, I think that it's a mistake to put the debate in exactly the terms you did by saying, well, the issue here is cybersecurity writ large. The encryption debate, at least the one that's been most prominent, isn't about whether things should be encrypted. I think everyone agrees we need encryption. It's absolutely appropriate. Businesses need it, governments need it, individuals need it. The question is whether, in particular, whether smartphones, and particularly iPhones, because they have such a dominant place in the market, should be absolutely impregnable, even in response to a search warrant, even when Apple is confronted with a search warrant, which would make them, I think, unique among almost any other device, and would therefore be unprecedented. To say that we should have that they should be amenable to search warrants, and of course, I don't think backdoor is the right way to do it. I think appropriate access under lawful circumstances when an independent judge has found the appropriate requirements under the Fourth Amendment. To say that we should be able to see that wouldn't be disastrous for cybersecurity or individual security at all. And it wouldn't be anything that I don't think, there's no evidence that there would be a boon for hackers. After all, from 2006 or whenever it was until late 2014, that's exactly the situation that we had. That we could and did present search warrants to Apple, to Google, and were able to get information from phones in order to help and resolve cases and get information. And I don't think that there's any instance in which that led to a breach of any kind, a breach of security. What you're talking about with the other hackers, and I think there are some times when there have been corporations or government entities that have had servers or other systems that have been hacked into, but I think that's a very different issue from something being amenable to a search warrant, from a phone being amenable to a search warrant. You point out, and it's right, of course, that we do have significant evidence from phones. We do have, there are tracking devices, there are places we can go to get information. There are cell phone site records that show where phones are at certain times. But there's no question that people have a tremendous amount of information on their phones, things that they used to have in their homes, and that now they keep on their phones, and that will be absolutely beyond the reach of law enforcement. And it matters to people. It matters, for example, and people know it, and they think, criminals think that that helps them, and they're right. we have talked about, for example, one case where there's an inmate in Rikers Island who was alleged to have and charged with trafficking in the sex trade and having prostitutes, and one of his phone calls was taped. That is, from the prison was taped. Absolutely appropriately and with warnings, et cetera. What was interesting there was his awareness of and concern for the iPhone, because what he said was, he was talking to a friend outside, he said, I need you to open up your iPhone and go to your operating system. If it's on an operating system 8, an iOS 8, they can't get into my phone. So he knew that he was safe if he had his stuff on an iOS 8. That's one instance. It'll be multiplied innumerable times. What we're proposing, while some see as a threat to security or as a serious invasion of privacy, I think is neither. What it is simply that iPhones be amenable to search warrants properly issued. The same standard that you have in your house, that we have in all of our personal effects.
So can I, Dan, I'm not sure how we could continue the conversation. Okay, so I'm going to push back against a couple things you said, Ben. I imagine you'll do the same after I finish. So I want to start with this notion of what sort of access you're asking for, because you kind of resist the nomenclature of backdoor and say instead appropriate access. And I think what cybersecurity professionals will tell you is that those are one and the same thing, that what in essence law enforcement is now asking for is a way to circumvent encryption on a device. And what every cybersecurity professional will tell you is that there's no way to build a device that is accessible only by the good guys and only for good purposes. The problem with the backdoor is that once you build this means of access, whether it's guarded by a warrant or not, as a technological matter, you can't keep out malicious actors. When you design a system to have a single point of failure, maybe it's Apple in the context of iPhones, maybe it's Microsoft in the context of the device encryption they've actually offered for, I think, at least a decade. This is not a novel phenomenon. If you work at a law firm or a financial firm, you've probably had device encryption on your laptop for quite some time. If you build that system, it becomes an irresistible target to hackers because the payoff is enormous if you hack this one single point of failure. That is why every cybersecurity professional out there will tell you they can't build what Director Comey has asked for, they can't build what District Attorney Cy Vance has asked for in a way that keeps the good guys secure and only exposes the bad guys' information. And virtually 100%, and in fact I think 100% of every computer scientist who's spoken publicly about this issue has said just that. And not a single computer scientist on the other side has come up with a proposal for how to offer the access law enforcement officials have been asking for without compromising the security of everyone else. And the debate has started to take on the kind of trappings of the climate change debate, where you have a row of scientists on one side saying one thing and politicians on the other saying, I don't believe you. And I think that for me is the kind of factual background that I start with. One other point to get to of something that you said, Ben. You've said that Apple's now default encryption on their devices has led to an unprecedented state of affairs. And I think that's wrong for a number of reasons. One is that it's actually not new of late for there to be device encryption. As I said a moment ago, if you use a laptop, particularly if you use one at a business, you probably have device encryption enabled. And that's a good thing, because otherwise if you left your laptop at an airport and it had your sensitive client's communications on it, or it had sensitive financial data, or maybe you worked for Health and Human Services and had sensitive medical information on the device, device encryption would protect that so that somebody at the airport who picked up your laptop wouldn't be able to exploit it. That has existed for some time and is the default in most, I think, industries that deal in sensitive information. But I think it's not true for two maybe more important reasons. The first of which is that encryption is actually it's been around since the nation's founding. Some of the earliest users of encryption were our nation's founders. Thomas Jefferson very famously communicated while he was in France with James Madison about the First Amendment, no less, using hand-performed ciphers because he did not trust those communications to be sent, which at the time were, of course, very subversive communications about the founding of a new government. Did not trust their delivery from interception. And after the founding, many of our nation's founders continued to use encryption and actually specialized in developing their own ciphers because they didn't trust the postmaster of the United States at the time. So encryption has always been around. But even more fundamentally, than that, for most of our country's history, most information that law enforcement today finds useful on digital devices simply did not exist because it was ephemeral. When you had a phone conversation, not a phone conversation, a conversation with someone in person, that was ephemeral by nature. And unless the government was monitoring you at that moment, it was lost forever. Even if you could make an argument later on, wouldn't it be great if we had that communication? Maybe that justifies forced data retention, forced recording of everything in public. As a matter of fact, it wasn't recorded. Most of this information was ephemeral, and only now, because of the rise of technology, do we have so much information that is captured by our devices. And so the real question is, how do we balance this new glut of information? And I think the answer is you allow law enforcement to take advantage of what it can access without fundamentally undermining the security of the system. And it's so important because we as a country have so much more to lose by having bad defense than we do by ensuring that we have good offense by weakening our security. So that's how I view the balance between the two.
Well, look, I mean, I guess what I'm not clear in your analysis is this. If there were to be access to someone's iPhone, and because Apple had a device or a means of responding to a warrant, I think that to get any information, a wrongdoer would need both that access to the iPhone and the iPhone itself. So you see, that's why I think this is a very different situation than the situation of hacking into a large server where you have thousands and thousands or millions of people's data. Here what we're asking for is for Apple to have a certain method. In the extraordinarily unlikely event that its method would become other people would become aware of it, those people would still need the device itself to get into it. And so,
maybe. It depends on how it's implemented. It depends on, security is hard. It's very difficult to build these systems.
Right. Well, I don't think Apple has remote access to things. They can unlock things. They don't have remote access to them. If they do, then I think we have a whole separate problem. But I think that the concern with the circumventing cybersecurity that you've put, I think, is in this case overstated for that reason. No one is suggesting we shouldn't use codes and ciphers. They've been around from even before James Madison. And they can be around still. But this is an extraordinary thing where the device that people have that has so much information, and it's really supplanted many other things. You say that, look, a lot of things are now kept that used to be ephemeral. That's partly right, but there are also photographs that people have. You used to be able to have, if you thought that photographs would be germane to a case and relevant, you thought they'd be in someone's house, you get a search warrant, you go into their house, and you'd be able to get them under appropriate circumstances. Now you can't. They're on the iPhone. There used to be that someone's contact information, their little black book. In innumerable cases, that would be an extraordinarily valuable thing that one would have to help to try to understand who someone's criminal confederates were. You no longer have that. The contact information is all on the iPhone. So now, even if you catch someone in the act of wrongdoing, and they have their iPhone on them, we won't be able to get that critical information. So there's a tremendous amount of information that we're losing that we used to be able to get because it's no longer available other than on the iPhone. I do agree with you that the issue here is a question of balance. And for that, we need, I think, more information. We've asked, and I think for the decision of how much information should be available, how much privacy should be, and how it should be, whether and in what circumstances the government should have access to it, isn't one I think that Apple should make itself. I think it's one that Congress has to make. And they should do it by hearing from Apple, by hearing from Google, by hearing from law enforcement. The District Attorney of New York and Jim Comey have both testified before Congress. The District Attorney has asked Apple in public letters information, including how often its security is breached, because one of the concerns you raise, and I think it's an appropriate concern, is how safe would it be if Apple were able to get into phones as it used to be able to do. Was that breached? Were there cyber problems there? And those are questions that we don't have answers to. I think we need them.
So I want to, you mentioned a few categories of information that you think that you no longer have access to. And I think, those categories seem wrong to me. You mentioned photos. There are some photos that may now reside solely on a phone, but for every one that's on the phone, there may be hundreds on social media that you never had access to before, because that entire ecosystem did not exist. And those are used in prosecutions routinely, from Facebook, from Twitter, from Instagram, all these avenues of social media where people share information. So it may be that people have greater control over their devices, but the total amount of information that is available to law enforcement has ballooned exponentially. It hasn't shrunk in any meaningful sense. And then the same is true for contact information. You may not be able to get it exactly from the device, but you can probably get it by a pen register, a trap and trace that captures every phone call they've received or made over the past 18 months for most providers. For some providers, going back to 1980. AT&T keeps that information going back to 1987, I believe. For every area in which that information, you lose a little bit of information, I think you've gained enormously through the benefit of technology. And I want to also add one point that I meant to mention at the beginning. I think it's important to understand which investigations backdoor access would help with. Because I think there's a reason why national security officials have all come down on the side of strong encryption. And the reason is, I think, because they recognize that backdoors are not a solution to sophisticated criminals. Because sophisticated criminals and terrorists do not rely on technologies that need intermediaries like Apple. There are plenty of encrypted communications and other pieces of software available through the free and open source market that are already kind of out of the bag, that anyone around the world can download freely and use, and terrorist groups do use, and those can't meaningfully be regulated by US law, and I don't think anyone really suggests that they can be. So for those sorts of individuals, for the sophisticated terrorists and criminals, if you shut off Apple, they'll turn to the alternatives that are available that will not be affected by any law. But there still is I think a real point that you make, which is that may be true, but default encryption still helps out the average criminal. And I think that's right. I think default encryption will help out at the margins the average criminal. But it's important to understand that is a criminal for whom you would have the major technology companies fundamentally weaken their systems. It's for the average criminal, not for the sophisticated criminal, not for the terrorist, but for the average criminal. And so the question is, is it worth it in that context to sacrifice, digital security?
Look, I can't say what terrorists would or wouldn't do and how sophisticated. I presume some will be more sophisticated than others, and people make mistakes, even people who should be very sophisticated. There are a lot of average criminals. I think that's a significant body there. The vast majority of cases are average criminals who do terrible things to people, and I think, and this average criminal in Rikers is just to call him the tip of the iceberg is an understatement.
He was sitting in jail at the time, by the way.
For how long and for what crimes and for everything. For what extent are huge questions of great importance to all communities across the United States. And I think that Apple's position does have an effect on our ability to prosecute those cases, millions of cases. Will it have an effect on the ability for terrorist cases? Well, I suppose there'll be terrorists, extraordinarily sophisticated people who get around it. But to make default encryption to millions upon millions upon millions of people is a real cost to law enforcement.
So this is a different kind of subject, but I recall, maybe I get this wrong, I recall that when Apple first announced its shift so default encryption has been on the device for actually quite some time. What happened in 2008 and I guess it was 2010, more information on the device, they shifted toward the default encryption. And I think I recall that when that happened, when they made that decision, New York Police Department officers actually were advising people to ensure that they had it turned on their devices because it reduced the risk of phone theft. Because you've asked for instances of what are the breaches that actually happen of this data, and one of the very real reasons why device encryption exists is because people lose their devices all the time, and it's important to make sure that when they lose their devices, the data on the devices is still secure. And maybe I have this wrong, but I think NYPD officers were happy to see that Apple had made this move because a big part of the complaint that NYPD gets is, I lost my iPhone, can you help me recover it? This was a way of at least minimizing that damage. Is that true? Am I making that up?
I don't think you're making it up.
Okay.
So
why the change in stance?
I think well, I don't think it is. I think what you're thinking of, or at least what I'm familiar with that sounds like what you're thinking of, is I think there are kill switches or something like that. There are Apple devices that if you don't know the password and you plug in a certain number of times, then it goes dead. And the reason I think that the police were very wanted Apple to do that was because the theory was then people will stop stealing iPhones, because essentially what they're stealing is just a brick or a small brick that is ineffective. I think that even under those circumstances, with that operating system, however, Apple could still get in. We could still send it to Apple with a warrant, and we could get in and get information off the phone. So this is a substantially different matter. And certainly Apple treated it as a different matter, because in 2014, in September, October 2014, one of the things it advertised when it said we now have iOS 8 was we will no longer be able to comply with search warrants or orders from law enforcement. So they considered it to be a significant difference from the past, and they touted that.
Should we open up to some?
I think there's a question.
Sure.
Just if you could talk a little bit more about, you don't really address like the volume issue. I mean, 'cause it seems like we have the Fourth Amendment regime that didn't really contemplate, you know, I that's not an original list. But the idea that I think that Alexander's making is that we have this like incredible volume now, and people are taking photographs that never would have taken photographs before, and every piece of information that's associated with it. And I haven't heard you, Ben, really address that. Is that like a stick to without a difference to you? Or do you think that our current Fourth Amendment regime adequately captures that problem that Alexander is bringing up?
Well, I guess I don't think the fact that people are taking more photographs supports the conclusion that therefore they should be unavailable to a properly issued warrant. I don't think that. Certainly there are the people at Rikers Island who may have taken many photographs and you know thought that he was better off having it on the iOS 8, and I think we were worse off. So I don't think that really answers the point.
Well, photographs is one thing, that also tracking devices, where you are, how long you were there, every movement that you made during the course of the day. I mean, not just photographs, but the volume of information.
There's no question that we have more different and more information, and technology helps to get that. I don't see how that answers the Fourth Amendment question, or the question of whether there should be something that has so much information on which so much can be done that we can't get to.
Can I just address the Fourth Amendment question for a second? Because, you know, in this debate, you hear this often, that even with a properly issued search warrant, we can't get access to information. And I think that misunderstands what a search warrant is. I mean, a search warrant is not a guarantee of the government's ability to understand what it acquires. It is an entitlement for the government to get access to a physical space and take something. And in the cases where the NYPD or other law enforcement agencies execute a search warrant and get encrypted data, they have gotten what a search warrant entitles them to. They're not entitled to then force somebody to translate that information for them. If, for example, you had a journal that you had written in a manually enciphered way, or say you had written it using allusion and double meaning, the government could not then use a search warrant as a basis to force you to translate that journal for them. You know, even if the government, you know, successfully forced Apple to stop offering default device encryption, individuals would still be able to encrypt their devices using, you know, this publicly available encryption software, because at the end of the day, after all, encryption is just math. They could still use that math to encrypt their devices, and the government would have no recourse. And I think that's as it should be, because the Fourth Amendment, neither the Fourth Amendment nor any other constitutional provision requires people to organize their lives in a way that facilitates government surveillance. I think quite the opposite.
Well, no one is suggesting that there's a Fourth Amendment, that the Fourth Amendment prevents Apple from doing what it's done. What's clear is that in order to prevent Apple to do what it's done requires legislation. The question is whether that legislation, whether it would be good policy or not to pass such legislation. We think it would be for the reasons that we've stated, and you think it wouldn't be. I think the answer is it has to be the decision must be the matter of public debate. As I've said, I think Congress is the right place to do it, rather than have Apple essentially unilaterally decide, which, if there's no debate, is what has happened and will happen.